The old man probably meant it when he said he'd leave his house to the relatives he'd invited to come care for him in his last days. Without anything in writing, though, the court in Burns versus McCormick had to think hard about whether the relatives' abandonment of their old lives to move in with him was sufficient to enforce an agreement for the transfer of land. James Halsey was an old widower who lived alone. He asked his relatives, James Burns and his wife, to come live with him in his house in Hornell, New York. He told them if they cared for him, his house and furniture would be theirs after his death. The Burnses sold their draying business and left their home in Andover to move in with Halsey. They lived with him and cared for him until he died 5 months later. Halsey never wrote down this promise to Burns or otherwise formalized a contract. John McCormick, executor of Halsey's will, refused to pass the house and furniture on to the Burnses. Burns brought an action in equity seeking specific performance of Halsey's promise. He claimed that he'd relied on Halsey's promise in performing his part of the oral agreement. McCormick countered that Burns didn't have a contract with Halsey because the agreement was barred under the statute of frauds. The trial court found for Burns. McCormick appealed to the New York Court of Appeals.